Let me take the opportunity to thank all of you for coming and also for inviting me to speak today. To Dean Bowman and to Jonathan Marshall and to our counterpart at Marshall University for hosting and putting together this inaugural seminar, CLE, and our students representatives also. First, also want to thank our regulators and our legal service providers, because you provide obviously not just the bookend pieces, but very critical aspects in allowing us to do our job in what we call advocating and protecting the rights of West Virginia consumers under the acts, not just the WVCCPA, but a slew of other acronyms. Very little of my work has to do with respect to the FDCPA and other federal ones in West Virginia. So therefore, some of the perspective when I talk about and the people we litigate against come in with a full understanding and a knowledge base of the FDCPA and the federal regulations. And as we all know as very current practitioners here, that West Virginia is and has some unique qualities that fall differently than some of the federal regulations. And therefore, there's a little bit of a training or a indoctrination that has to occur, unfortunately, with some of our counterparts. So the industry, as Lauren said, that are well regulated and represented in West Virginia, I believe, understand that and get it, and they are really working. The ones that are regulated well really work well and don't have a problem. On our first slide, let me say very quickly and clearly, in doing this, I've been practicing 30 years, primarily all civil and criminal trial litigation, and have across the entire state, and now, fortunately or unfortunately, because of matters that I guess turn good or bad, go across the country doing some of this work. Now, with respect to that, I bring to you then a litigation perspective that talks about how do you prepare the case, because I still believe, and I do believe, the WVCCPA and other consumer protection statutes, whether it's data breach, privacy, identity theft, or however, home mortgage loans, that if you treat them the way that they are deserved to be under the rules of civil procedure, you will move your case and your client's result will be better at the end. There's a lot of perception, sometimes primarily by those on our opposing side, if you're representing consumers, that there are inventories, that these are matters that can be resolved through some high level of compromise and some just a little, let's throw some numbers around. It seems like these are extra things that your clients don't deserve but will give. We don't take that approach. Under this particular legal climate that we have, we should embrace the statutes. They are clear. They are direct. And in no better place than a strict constructionist would like clear, direct statutes. Very little wiggle room. Unlike my previous life form doing personal injury work and some criminal work, there's a lot of gray area in those practices. You can preside and present in a very unique position here doing the consumer work. What we do is we talk about the parties, putting the parties together, having a very systematic approach to when the case comes in. You also have a lot of repeat players on the other side, so you're able to adjust and adapt to the different counsel that come in. You don't have, as in some civil lit, you may have 70, 80 different lawyers come across. What we find now is you have about maybe 20 that are repeat players all the time. There's standard practices that they have, and then you begin to develop. But what it also teaches you that consistency on your part is necessary in the very beginning. The way you treat the case at the very beginning and the consistency you have will carry itself on. Now, related cases, we all have those, because whether it's a phone call case, whether it's a particular letter case, or it's a disclosure case, or a notification, or if it's a document case, we're going to have those. And you want to keep track of those electronically in your office so that you know that. We come back. Are you experiencing whether you were dealing with insurance adjusters or risk managers? A big difference psychologically and also monetarily in how you can achieve the end results for your clients, because those are two different areas. And sometimes they mix, because you'll have reserves that are going to be spent first, And once that's exhausted, you may go into coverage issues. So your change will occur when you try to litigate your case. The facts of the case, well, you say, hey, just do I know the facts? No, do you really, really know the facts of your case? Did you sit down? In our office, we yell and scream about one and done, one and done, one and done. That is, let's have one good meeting and be done. Meaning, not, hey, let's talk to the client for a few minutes or 10 minutes, 20 minutes, and not get all the facts, and then have to keep calling back about something. That's not helpful. It never is helpful. Now, liability assessment and damage model, very critical. Think about whether, if you're going to do this work in this space a lot, do you have a business evaluation expert? And that is not an expert, a consultant. Because as you're suing, ABC Recovery, who are they? Do you have their financial forms? Are they on Dun & Bradstreet? What is their background? What's going on in their company that may affect the facts of whether you can settle your case, resolve your case, where's the pinch point, what's happening? And then preconditions. Many of you that practice this, you're going to have, whether it's little idiosyncrasies that occur in your client's case. They may need special things. It may involve whether if it's a repossession, or if it's a forgiveness, or if it's a tax issue, or if it's a complication with respect to co-signers. You have to have those preconditions, and you should know them well in advance. A special location, so that you don't scramble around, because one thing I know, once the deal is cut, nobody wants to go back and renegotiate the deal. Neither the defendant nor the consumer at any given time. And then special considerations, it just happens. I mean, one special consideration can sometimes be, we had I'll give you an example, a lender was closing in with respect to a veteran, and they were just came off, they were not active duty, but they were a veteran, and this was a particular company that probably did not want to be associated with closing in with respect to veterans. It's not in their business model, and those are special considerations that occur. Now, in our next slide, we're going to talk more about how to move that case. How many of you, I know a lot of you are regulators and legal service providers. Outside of that, how many of you are actually litigating these cases, we'll say in the private sector? I see a good number of hands up. Now, as you litigate those cases in the private sector, and those friends of ours who are watching on closed circuit television, you have your discovery, and what happens there is, there's an old saying also in my office, cut and paste. You cut and paste, and I'm going to do something else to you, okay? And I won't say what that is. But people, I don't mind not reinventing the wheel. But you cut and paste, and you leave something in that shouldn't be in, I will deal with you. And I deal promptly, and everybody knows I will judge harshly, but promptly, both give credit or take it away. There's no need to worry about coming later, because it's our product that goes out the door, but it's your client's results that are going to get affected. Now, interrogatories, requests for production of documents, and requests for admissions. The RFAs scare the living jeebers out of the defendants, okay? With the exception of a few defendants. They all squeeze and weasel out of answering these things. There's costs at the end of the day if you're able to prove those matters. And as you go later and you move for judgment and you prove it, not only do you get those costs, you'll have your fee shifting also, but the cost on the request for admission, improving the actual aspect. And that admission later on will lead to some other consequences for yourself. Now, follow-up. This is what's really important right here as we move through what we talk about, the deficiency letter. This is where you can get quagmired if you're litigating cases. If you allow yourself to get involved in, hey, the discovery goes out and it's no good. Nobody answers, nobody wants to answer for 1,000 reasons. Your deficiency letter, after about 5 cases, you have a deficiency letter already generated in your office, because surprisingly enough, the people we litigate with really do not come up with any new objections. They don't. They're all standard objections. You litigate, you find out what they are, you create the template, you throw it in, you have a deficiency letter that may be 18, 19 pages long, you do it. It's a one and done operation. Once you do the deficiency letter, ours will roll out sometimes at 13, 18 pages. Next thing you know, you meet and confer. It's not a taffy pool, and you'll hear that term a lot used by me during discovery. We don't get involved in taffy pools, and we'll meet, We'll talk about it. Next thing you know, motion to compel gets filed. That deficiency letter gets attached. You don't need to do much more because it's one and done. If you do it right, you're not tied down to a bunch of crazy litigation, wasting your paralegal's time, wasting everybody else's time, or the court. You pick out 3, and there's always good 3 very critical objections that they've made. You pick those out, and by that time, everyone's moved forward. A discovery commissioner, they're fine to have, but one thing I know is this: a discovery commissioner is a lawyer. They want to try to figure it out, and some things just cannot be split in 2. These are not, it's just not that way. It's either you're going to get it or not. Think about the question you're asking. Now, as we go through 30B7, we send them out all the time. We attempt to take them, surprisingly. It never, hardly ever gets to that. They cannot allow that to happen, won't allow those things to happen, but you push for it. Nobody moves a case unless you have a trial date. A trial date, a trial date, a trial date moves a case. Get it ASAP. Failure to get it, you let your case languish, that's going to happen. Witness preparation. Another place where young lawyers and experienced lawyers lose out by not preparing their client for this type of litigation questioning. If you don't know, sit down with somebody and figure out, read a few old depositions and find out why your clients, where the pinch points are your client. You think, hey, this is just a statutory case, we're going to be involved, not a problem. It becomes a problem because the client can really, really just get completely confused and cause you a lot of work. It doesn't mean that your case is gone. It just creates a lot of work for you to try to come back and make some clean up or clear up things. The other thing is mediation. Everybody loves it. We enjoy it. Don't place all your basket or all your eggs in that basket of mediation, okay? Because here's what it is. It's another place that somebody wants to try to figure out, can I resolve it cheaper, quicker? Sure, maybe, maybe not, because they want to try mediation close to trial, so I don't know if it's really quicker. And is it ever cheaper? Not really, because everybody just wants a discount on it. By that time, you should think about 3 things. We talk about right, light, and fright. Right, light, and fright. Be right about the law, about the facts of your case, and that what you're doing is right. Do you feel that it is right? Do you believe that it is right? Bring light to the issue, light to the judge, and light upon what the defendant or the person you're suing is doing. Then number 3 will occur, fright. You will eliminate your fright, and you will cause the other side to have fright, whatever that means for them. But it brings people to the table a lot easier when you have right, light, and fright. Thank you.